Hello to my contracts class. This is the beginning of week 4. We are now more than halfway through the semester and we are starting the other half of the summer session 1 course in law of contracts. So last week on Thursday I sent you your first exam on chapters 11, 12, and 13. It will be due Tuesday, the 9th of June by no later than 6:30 p.m. And I wanted to just give you a few pointers, which I talked about last week. These are essay exams, and so it is extremely important that you write full essays answering every part of every question asked so you get the full amount of points possible for each and every question on the exam. Use your text, use your notes if you have any, use my notes, and be sure you are writing full, long essay answers. Now, what's an essay or long? Well, I mean, some are longer than others. You are going to be giving me a lot of definitions. Make sure you give me the full definition, not just a one-line answer. Okay, so that's for the first exam, and this week you are going to be reading chapter 14 and 15. So we'll start with chapter 14 first. Please read it. It is on capacity and legality, and we're going to talk a little bit about that. One of the reasons or one of the requirements for a valid enforceable contract in the courts is going to be that the parties to the contract have what we call legal capacity. In other words, they are recognized as understanding the terms of the contract and having the mental capability, both from a legal standpoint and from an individual standpoint, to enter into and be held to the terms of any contract. Also, the subject matter, the purpose of the contract must be a legal purpose. You cannot hire someone to assault someone else, and then when they refuse to do it, go to court and say, well, they breached the contract, because the purpose, the goal of that contract was not legal to begin with, and therefore would not be able to be enforced under any circumstances. Okay, so looking at chapter 14, I would like to just pull out a few things in that chapter. It starts to talk about, at the very beginning of the chapter, contractual capacity and minors. So in most states today and throughout the history of this country, we talk about the age of majority. And the age of majority, meaning the age when the law is going to recognize someone as being an adult rather than a minor, is the age of 18. If you are under 18, you can enter into contracts. However, the person entering into a contract with a minor always risks that that minor may want to get out of that contract. And because they are a minor, there is a presumption under the law that that minor cannot be held for the responsibilities they've agreed to. Now that means that the other party or parties to a contract could be left losing out, losing property or money, whatever consideration or property was the subject matter of the contract, if they chance it and enter into a contract with a minor. The general rule that we talk about is that a minor can enter into a contract that an adult could enter into, except contracts prohibited by law for minors. However, you have to understand that there is something called disaffirmance, or the ability to disaffirm, and that means a minor can set the obligations in the contract aside and not have to follow them. That's disaffirmance. And it says, to disaffirm, a minor must express their intent through either their words or their conduct not to be bound by the contract. And you'll see in the book that not only does this apply to a minor, but it also applies to someone who was a minor when they entered into the contract, and then after turning 18, within a reasonable time, and it'll be up to a court to decide what's reasonable under the circumstances, they can disaffirm. They can still get out of the contract. Now, it doesn't mean that they can, disaffirm late or when the court thinks that they knew what they were doing, because the courts also will say that if a person enters into a contract when they're a minor, turns 18 and continues to follow the contract, that is telling the court that they are ratifying or agreeing to the terms of that contract after they turned 18. So again, there's no set rule like they have to, within a week of turning 18 or a month. In those kinds of cases, courts will look at the circumstances and decide if the minor can still get out of the contract a short time after they turn 18, or if their words or conduct once they turned 18 show that they were willing to keep with the contract and the terms under the contract. Okay. Ratification. In this chapter, we're going to learn about ratification. So they define ratification as the act of accepting and giving legal force to an obligation that previously was not enforceable. And that would be one of the things I talked about. A minor enters into a contract before they turn 18. Then they turn 18 and within a reasonable time do not try to get out of the contract. The court looks at that as ratification. That means that they are, by words or conduct, letting the court know that they have decided that they will agree to the contract, that they will continue with it and be bound by it. There are other circumstances in which ratification takes place. Let me give you an example. So if I'm talking to the class and I say, my husband loves Corvettes. I've been looking for a 1968 Corvette for several years, but they're all too expensive. I'm not willing to pay more than $10,000, and it has to be running, and it has to have air conditioning, and it can't be green. And I'm telling my class this, and then one of my students is out at a car show and finds a car, a Corvette, that fits those descriptions, and enters into a contract as my agent on behalf of me, telling the person that, they're my agent, they're working for me, and they sign a contract, which legally I could be bound by. However, when they did that, they did not have my permission to enter into a contract on my behalf. And so what happens is I will not be legally bound by that contract. But let's say I look at the contract, I look at the car, it has everything I want. I can ratify the agreement that my student entered into. What that does is it's me saying, I like this, I'm willing to go along with this and be bound by it, even though at the time it was made, I did not authorize that to be a contract I entered into. So ratification can be in the case of a minor who turns 18 and wants to be bound by the terms of the contract. It could be a circumstance where someone says they represent someone and enters into a contract on their behalf, when in reality they don't have that authority. But if the person that they say they entered into on their behalf likes the deal, then they can find themselves saying, yes, I'll be bound by it. That's ratification. What about parents' liability? What responsibility do parents have when a minor enters into a contract? Well, generally speaking, since common law, when we talk about minors entering into contracts, the minor is the one who is responsible, except in the case of what is called necessaries. Now, if a minor enters into a contract for food or shelter, clothing, they may be told that they will have to honor that contract and pay for those things, which we call necessaries. However, if they're under the age of 18, their parents have that liability, not for other things like buying a new car or something like that, but there are certain circumstances where parents would be liable for the necessaries, the food, the clothing, the shelter for their minor child. Okay, mental incompetence. So even though being a minor is a form of not having legal capacity, let's talk for a minute about a person who has been deemed incompetent. Now, if that person has been deemed incompetent by a court and has a guardian, any contract the person enters into without the consent of their guardian will not be enforceable because they do not have the legal capacity to enter into a contract. If they have not yet been adjudicated, if they have not yet been appointed a guardian and enter into a contract, it will depend on the circumstances of what they understood at the time they entered into the contract. And again, be sure you read in chapter 14 all of these examples that they give of different types of situations. Let's see. Let's talk about contracts and covenants not to compete in employment contracts. So what happens is, what happens is, let's say that you are you graduate from Johnson & Wales Culinary, and you have a degree in pastry making, and you go up to this restaurant and they employ you, but it's your first real job. And the bakery itself and the people who own it are very famous. Maybe they have a TV show even. And so before they hire you to be employed by them, what they are going to do is they are going to have you sign a contract, and the subject matter of that contract is that you have to agree that if they hire you and you at some point decide to leave them, that you cannot compete with them. And they will talk about the distance. In other words, you can't set up a shop, a bakery, within so many miles of the one that we have, or within the city, and that you can't do that and compete with us directly for a period of time. Now, so we're talking about distance, the area that you agree not to compete in, and the number, the months or years that you are going to be held to this once you leave the employment. Covenants not to compete, contracts that are covenants not to compete, are enforceable. However, the court will judge whether they are enforceable or not based on the reasonableness of the covenant itself. If you have a covenant not to compete and you get someone to agree they can never work for anyone else or open their own bakery for the rest of their professional life, that's not going to be reasonable. If you say you can't work for any of our competitors for a period of 5 years, that's not reasonable. There's no magic number, no magic distance, but the courts will look at any of those contracts. If someone is saying you breached the contract, you went against it after you left us, and decide if it's reasonable. And if it is, if the terms are reasonable, then the court will enforce that contract. If they're not, then the court may find them to be unconscionable, meaning so out of the realm of fairness that the court will not enforce them. And usually unconscionable contracts are described as unscrupulous or grossly unfair, almost to the point of shocking the conscience. Exculpatory clauses are also in chapter 14, extremely important. Exculpatory clauses. They release a party from liability in the event of economic or physical injury, no matter who is at fault. Okay? Courts sometimes enforce these contracts if you agree to them and you know the risk you're facing, and other times feel that they may be unconscionable and not enforce them. Again, I am just picking a few things out of the chapter to bring your attention to it, as they are some of the really important parts of this, but there are lots of important parts. Near the end, they talk about the legality or illegality of a contract. Any contract that the court finds is illegal by the very nature of the contract itself, that contract would be described as void, as if no contract exists and it would not be enforced by the courts. And you can see towards the end of the chapter that they give us many examples of contracts that either the court has decided they were entered into under fraud, false pretenses, lies, duress and undue influence, threats, and they will not be enforced. The last thing I want to talk about in chapter 14 is one of the last things in the chapter itself, and it's called severable contracts. Every good contract should have what is called a severability clause. A severability clause, let me define it in my terms. It should have a clause that states if for any reason any part of this contract is deemed to be illegal or unenforceable, that part only will be severed or taken out of or struck down in the contract, and the rest of the contract will remain enforceable. Severability clauses allow us to, in the event that something is illegal or unjust in a contract, that the courts can take that part out, separate, strike it down, and leave the rest of the contract intact. And so every good contract, and that also includes every good will or trust, should have a severability clause to protect the overall contract or will or trust, and not let one part of it that might later be found to be unenforceable, unconstitutional, make the entire document be struck down by a court. Okay, so that's a little overview of chapter 14. On Thursday of this week, I'm going to assign chapter 15 for you, which is on mistakes, fraud, and the courts deciding if the consent to enter into a contract is voluntary or not. Now, people make mistakes. Even with written contracts that you think are well written and clear, and you think there is a meeting of the minds of the parties as to what it says and what it means, we know through cases that have gone before the court that often people make mistakes, misinterpret things, interpret words in a contract or parts of a contract in a way that is different from one of the other parties, and it eventually causes some kind of problem and the case ends up in court. We're going to talk in that chapter, you're going to see unilateral mistakes where only one party, bilateral mistakes where both parties, and how the courts generally rule on these types of cases. Also, mistakes of value. It says if a mistake concerns the future market value or quality of the object of the contract, the mistake is one of value, and normally the courts are not going to change that. They're going to enforce the contract. Also, we'll talk about fraudulent misrepresentation. Now, when we talk, fraudulent misrepresentation is a nice legal term for people lying, generally speaking. And typically, fraudulent misrepresentation will consist of the following elements that you would have to show to have a court strike down a contract based on fraudulent misrepresentation. One, that the misrepresentation was of a substantial and material fact upon which the contract was based. Two, that there was intent to deceive. Three, the innocent party must justifiably rely on the misrepresentation. And four, to collect damages if there is an accusation of a breach, a party must have been harmed as a result of that misrepresentation. Okay. And they talk about misrepresentation by conduct, and they talk about things like statements of opinion. Someone's opinion is not fact, and it shouldn't be taken as fact, and you can't later base a contract that you don't think turned out well, stating that this is what they said, that it was their opinion and it was not based on fact. Now, when you get a misrepresentation of the law, these kinds of cases can go either way. These kinds of cases, if you are dealing, say, with a real estate agent, and they tell you that a piece of property that you want to buy is zoned for commercial purposes, and you buy it based on that, and it turns out that that is not true, and you cannot build your business on this, then because that real estate agent is a professional and maybe an expert in that field, a court may say that that is a misrepresentation and allow the party who's been hurt to get out of the contract. However, in most cases where someone has misrepresented the law, the courts are very strict. The courts believe that if you are buying that property for a specific purpose, you have a duty to either hire, say, an attorney or someone in that field who can tell you what you need to know about it, or you have to do the research yourself. Again, I know I say it every time with every chapter, assume if you sign a contract, you're going to be held by that contract, even if later on you find out it disfavors you. Okay, and then they go through all of those different elements. They'll talk about undue influence, where one party greatly influences another party, almost overwhelming them and forcing them in a sense to sign a contract that they truly don't want to sign. They talk about duress. They talk about adhesion contracts. Now, these kinds of contracts are very interesting. First, they define them in our text as contracts that are written exclusively by one party, presented to the other party in a sort of take it or leave it. There's no real negotiations, and as a result, the party signs it, but they really feel like they had no choice, they had no bargain for consideration. Those are adhesion contracts. We see that a lot where someone says, well, this is the form we always use. You either sign it or forget it. But again, it's important to look at that part of the chapter. Let's see. All right. So that is an overview of chapter 14 and 15, which you will be reading this week. On Tuesday, I will assign 14 so that you read it. I will then later in the week send you my lecture notes on chapter 14. For Thursday, I will assign you to read chapter 15, and then probably the next week send you my lecture notes on 15. We then will have chapter 16 left, and 18 and 19. We are skipping chapter 17 because the material in chapter 17 I weave into other chapters. So 14 and 15, and your test is due Tuesday, no later than 6:30. And we are, after this week, we are winding down. We have a few more chapters. You have a final exam. You'll have, I forget if you have a couple more of the assignments that are worth points that will be added together to form one test grade, so that at the end of this summer session you will have done several written assignments that together those points you got for each one will be added together for a test. Your midterm will be your second grade, and your final will be your third. Those three will be averaged in to get your final course grade. All right, have a wonderful week 4 in summer session, and I will talk to you again next week. Take care.